Good morning. Thank you guys for being here today. I'm Sarah Langlois. I'm a partner at Rogers, Morris & Grover here in Houston, and we practice school law. And I've had the pleasure of representing HCDE as its general counsel for the past 8 years already. I've done this training before, and so some of you will remember me, hopefully, and more importantly, will remember some of the content. And not much has changed in the world of FERPA. So how many people, first of all, know what FERPA is, have heard of it before? Okay, that's good. And for those of you who have not, this is what this training is for. You are certainly not alone. I do FERPA trainings quite a bit because it applies to everybody in the educational institution, from teachers to administrators to people like you guys. And every time I do this training, there's probably a third of the room that all of a sudden, at some point in the training, I can look out and I see people just turn white. And they go, and I imagine what they're saying is, oh, and they're thinking, I did that. I wonder if I shouldn't have given out that information. I should have double checked. Oh my gosh, what will happen to me? Well, the good news is that there is no case law about FERPA. In other words, no court has ruled that an individual has violated FERPA because there's no private cause of action for violation of FERPA. So that's good news and bad news, right? It's good news because nobody thus far has gotten sued over FERPA. The bad news is we're sort of left to ourselves to interpret what all these regulations mean. Now, there is the Family Policy and Compliance Office, which I affectionately refer to as the FERPA police, and they are charged, they're up in DC, and they are charged with interpreting the FERPA regulations and issuing guidance. Now, we were talking a little bit earlier before it started about how the FPCO, the FERPA police, they issue these big, long, guidance letters and FAQs, and their website's full of all this stuff that on first blush, you go to the website and you're like, this is great, this is all this information, everything I ever wanted to know about FERPA. And then you read it, and it's not really giving you a whole lot of advice. It's other than just repeating what the regulations say. And so a lot of times with FERPA, it's a judgment call. It's sort of a gut reaction of, what should I do in this situation? Should I disclose this information to this person, or should I ask for additional information? Does an exception apply, etc.? So that's what we're going to be talking about today. If you have a question, please don't wait till the end. Raise your hand. It's a small group. Let's be as interactive as we can. However, if I tell you you're being an overachiever, that we're going to get there, don't get offended. Okay, so what is FERPA? FERPA is the Family Educational Rights and Privacy Act. It is a federal law. So it applies, it's governed by the U.S. Code, that specific section there, and then it provides further detail in the Code of Federal Regulations. In terms of policy, for those school districts in which HCD is one that subscribe to TASB policy services, and the vast majority of school districts do, FERPA is going to be addressed in Policy FL. The legal policy obviously will be FERPA, the law, and the local policy will be specific to that individual school district. And the local policy can differ it often does differ from one school district to the next. What does FERPA do? It primarily does two things. It grants parents and eligible students, and we'll define what eligible students are in a minute, the right to inspect their education records. It also protects the confidentiality of education records. Those are called FERPA rights. When we talk about what parental rights and the eligible student rights under FERPA, that's what's referred to as FERPA rights. How long do they last? Well, as with most legal determinations, it depends. Forever, as long as the student is alive. Even if the student is over 18, is age 50, FERPA rights continue. Deceased students, however, if the student is 18 or older at the time of death, then the FERPA rights disappear. Poof, they are gone. If the student is under the age of 18, that means the parent still has the FERPA rights, and so they continue. When does FERPA apply? FERPA applies to all schools receiving federal funds. So, of course, that's HCDE, that's HISD, that's Cy-Fair, that's Spring Branch, that's Pasadena, that's Beaumont, that's even most of your charter schools receive federal funds. And so virtually FERPA applies to all school districts across the nation because it's very, very rare for a school district not to accept some type of federal funds. FERPA regulates the disclosure of two categories of information. So when we talk about FERPA, remember it's education records, but it's also what's called personally identifiable information. And we'll define what those two categories are. First, what is an education record? To constitute an education record, it has to meet very specific criteria. But the definition of education record is very broad. It includes records that are directly related to a student and that are maintained by the educational institution or, is most often the case with Texas Virtual Schools, a party acting for the educational institution. Very important, education records can exist in any form. Most of the time when we think about records, we think about paper, and we think about transcripts and grades, etc. However, in the digital age that we live in, which you guys are very aware of since you are virtual schools, it can also exist in many different forms, like emails, if it's a Word document, if it's a PDF document. It doesn't have to be physically printed out in order to be considered maintained by an educational institution or a party acting for an educational institution. It can also, sorry, sure.
Many times when I'm talking with folks on the phone, I don't have the student's name. I might have the school district they're working in, but I don't have the student's name. They try to tell me, I'm like, I do not have an educational need to know.
Right.
So, I try to cut them off the pass and say, so, let's not
let's speak hypothetically
exactly right.
about. Don't tell me about this specific student who's age 18 who attends this particular high school who da 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 da. It's just
student in our campus that's taking underwater basket weaving
or whatever it is. Right. I think that's a good practice, and we'll get to education. What is a legitimate educational interest in a second? Overachiever.
The counselor.
But importantly, education records, again, not just paper, but really anything. Videotapes, film. Somebody mentioned earlier about metadata, that there's been a lot of talk about metadata. Metadata, for those of you who are, and this is a very simplistic definition of metadata because I am by no means a technology oriented, but metadata is the data behind the data. And so, for example, with a Word document, the metadata would be the information that you can pull up that would show who created the document, what time it was created, whether it was edited, whether it was opened by somebody else, whether it was changed and who it was changed by, how many times it was changed. All of that stuff now I say you, not me. Some people are able to figure out what the metadata is. And there's been a lot of talk recently about what are FERPA implications with metadata, et cetera. Theoretically, you could have metadata that is protected by FERPA. So for example, if a student created a document, how many times the student how many times the student edited it, what edits were made, what time it was, all that stuff would be an education record of a student. However, I think practically, this question isn't going to come up very much because we're dealing more with the actual records and the substance of the records as opposed to the metadata. But I just wanted to mention that. So education records can take numerous forms. Obviously, report cards, progress reports, class schedules, student ID numbers, basically any information, any record about a student is likely going to be considered an education record because of that broad definition of directly related to a student and maintained by the educational institution. Because the definition of education record is so broad, sometimes it's easier to talk about what's not an education record as opposed to what is. So what is not an education record? Something that the FERPA police like to refer to as a memory jogger. And it is a record of instructional, supervisory, and administrative personnel and educational personnel who are related to those people that meet 3 criteria. First, it's kept in the sole possession of the maker. Second, it's used only as a personal memory aid. And finally, it's not accessible or revealed to any other person except a temporary substitute for the maker of the record. So what are memory joggers? You have a notepad on the side of your desk and you're jotting down notes. Those are not education records under FERPA. FERPA makes a specific exception for these memory jogger type documents.
All right, Angela, our Post-its are safe.
Your Post-its are safe. However, of course, there's always a but, right? Even though FERPA doesn't apply, arguably if a parent or eligible student asked to see such a record, Texas law likely allows them access to that record because Chapter 38 of the Texas Education Code allows parents and guardians to access their student records, including medical records or any type of other records that are maintained by the district. So even though sole possession memory jogger records are not subject to FERPA, the records must likely be disclosed to parents if they ask for them under Texas law. Not under federal law, under FERPA, but under Texas law.
So we won't run crazy here. No.
That's right. No more beware of ex-parent. This exception likely will not apply to you guys, but I just throw it out there for your knowledge. Law enforcement records made by a school district police department. So for example, Spring Branch has its own police department, as do other school districts. If it's created by that law enforcement unit exclusively for a law enforcement purpose, i.e. not for a disciplinary purpose or not for any other purpose, and it's maintained by that law enforcement unit, it's not considered to be educational records. You guys likely won't come into contact with those records, but I throw it out there just so you know. Okay, a lot of times you'll hear about directory information. Has anybody ever heard of directory information before? Somebody will say, of course you can give me that information. It's directory information. Well, the answer to that is always maybe. Directory information can be disclosed only if it's been designated by that particular school district as directory information. Examples of directory information can include, but a district can pick and choose out of this list here what information they're going to designate as directory information. As a general rule, directory information is information that's contained in a student's education record, but that's typically not considered to be harmful if it's disclosed, or an invasion of privacy if it's disclosed. So for example, the student's name, address, telephone listing, date and place of birth, honors and awards, athletic type information like weight and height of members of the athletic teams, participation in extracurricular activities, that kind of, photograph, a yearbook photo, the grade level, that kind of thing. But what's very important is that, as I said, the district can pick and choose what directory information to designate. For example, HCDE has decided not to designate any information as directory information. If you look in policy FL local, which is where you'll find which information, if any, has been designated directory information by a school district. If you looked at HCDE's policy FL local, you won't see anything about directory information because they haven't designated it as directory information. Also very, very important, even if a school district has designated information as directory information, each school year, if you're a parent, you'll recall this, in the plethora of documents that get sent home on the first day, one of those documents is what's called an opt-out form. that even if the district has designated certain information as directory information, the parent or eligible student can opt out of directory information and check the box and say, no, I don't want any of this information released about my student. So you have to go one step further when dealing with directory information of A, is it designated as directory information by the district, and B, has this particular student, or his parents rather, opted out of directory information. General rules for contractors. Most ISD's FL local policy includes language like this. It'll say all contractors provided with student records shall follow the same rules as employees concerning privacy of the records and shall return the records upon completion of the assignment. In other words, if you have access to student records by virtue of your job, in which all of you do, then you have to follow FERPA because it's applicable to the school districts. Okay. Remember, FERPA applies to two categories of information. Everything we just talked about are education records. It also applies to personally identifiable information. What is personally identifiable information? All of the things listed here. The name of the student, parent, or other family member, the address of the student or family member, a personal identifier like a social security number or a district ID other than a social security number, biometric records like fingerprints, facial characteristics, so videos of students that show students' faces are protected by FERPA. Handwriting is also protected by FERPA because it's considered to be a biometric record. Indirect identifiers like date and place of birth or mother's maiden name, things like that. And this very broad category of information, that's other information that either alone or in combination is linkable to a specific student. To meet this criteria, you have to follow several different steps. First, the information must allow a reasonable person in the school community with no necessary specific personal knowledge of the relevant circumstances to identify that student. Second, you have to look to the surrounding circumstances, including local news, media coverage, etc., to see if other information may identify the student. Third, other information applies to prohibit the release of redacted or statistical information if other information, even if you redact it, still allows an individual to identify the student. So, for example, that's a lot of convoluted language, and it's really just a common sense sort of standard. So, for example, let's say you receive a request for information from let me use a real life example. You'll recall, unfortunately, a few years ago, a student at one of HCDE's special schools stole the keys out of the teacher's purse and ran into the parking lot and stole the car. Well, there's security camera footage. There's security cameras all around school, and so the local news media requested the video footage of the school. Normally, what we would do is we would redact the facial characteristics of the student because that's personally identifiable information. But in that particular circumstance, mom of the student had already been on the news talking about her kid's name, what school he attended, what grade he was in, all of this stuff. So that was already out there. So if we redacted it, were we protecting the student's personally identifiable information? No, because the other information would have given, if we released the video footage, the other information that was already in the media would have allowed a reasonable person to conclude, well, I know who that is. You blurred his face, but I know exactly who that is because of the previous news footage. And so in that case, we withheld it and would not release it to the media because of this other information exception to FERPA. So and then finally, personally identifiable information is information requested by a person who the district reasonably believes knows the identity of the student to whom the records relate. Okay. What FERPA rights do parents and eligible students have? They have basically 3 broad rights. First, they have the right to inspect and review education records. Second, they have a right to request amendment. Do they have a right to come in and say, that B should be an A. I don't agree with the grade. They can request amendment of the education record. That doesn't mean you have to do it. They also have the right to control who has access to their education records and personally identifiable information. As a general proposition, parents and eligible students do not have a right to copies. FERPA solely speaks to a right of access. But, and there's always a but, if the failure to give copies effectively denies access to the information, so for example, the parent, you guys have the information and the parent is up in Plano, well, if you don't provide a copy, I mean, it's sort of a gut reaction of it's pretty ridiculous to require the parent to drive down to inspect their child's education record. And so in that instance, I would say provide a copy. Skype. If you provide a copy, you can charge a reasonable fee. Okay, who can access education records? We've been talking about parents and eligible students. Parents of children under the age of 18 can access education records. A parent is defined to include basically any type of parent figure you can imagine. A natural parent, a guardian, an individual acting as a parent in the absence of a parent or guardian, like a grandparent. What about divorced or separated parents? Anybody ever had to deal with that? Where where mom calls and tells you how awful dad is and how they're going through this nasty divorce, etc. And she does not want dad to have any access to any information about their child whatsoever. What do? Ding, 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 ding. Do you have a court order? Exactly, if you have a divorce decree, but one parent cannot unilaterally restrict the information to another parent. Only a court can do that. So unless somebody can show you proof with a court order, a divorce decree, something like that, showing either that person's parental rights have been terminated, they do not have any more parental rights, or that their parental rights are restricted in some way that they are not allowed access to that education record. Other than that, that parent still has access to their child's education record. Yes, ma'am.
Define in the absence of.
That's a tricky one.
We get a lot of those on the phone.
Yes.
That's a tricky one.
Mom is here, or dad's around, I'm trying to help,
and they're getting ready to go into an art, and I work in the district.
and the help desk likes to help, and we like to help.
Exactly.
Right. I mean, and that's,
It's hard to draw the line.
unfortunately, there is no black and white line. I mean, that's where sort of, this theory of, and well, here's what the law says, and the practical reality of the student needs to be served. Sometimes those two conflict. And so in those instances, my advice is to take reasonable precautions to identify who you're giving the information to. And we'll go through the exceptions. Do they have parental permission? That's one way to do it. If the parent has signed permission for grandparent or for aunt and uncle or whoever, oftentimes that's not the case. Oftentimes, this kid is stays with whoever it is that they're staying with. In that instance, I would just take reasonable precautions. In other words, see if there's parental consent. Call the district and see, who is your contact? Who is listed as this student's guardian or parent? Or on whatever. Who is the report card sent to at the end of the year? All those kinds of things. And then document what you did to verify, to the extent that you can, who this person is and whether or not they have access to the information. But at the end of the day,
Go back to whoever our contact is with that kid's district.
right, exactly.
And some of those people disappear in the summer.
Yes.
So you're hearing this huge sob story and don't know quite what to do.
And those are hard judgment calls to make. They are. But so long, in my opinion, so long as you can show that you made a reasonable effort to verify who this person is and whether they have a legitimate access, they have legitimate access to this child's information, including their education records, I think you'll be okay. So, accessing education records, parents of students who are under the age of 18, and then the FERPA rights transfer to the student once the student becomes 18. However, and again, there's always a but, right? The parent retains the right to review records without the consent of the student if the student is a dependent of the parent as defined by IRS purposes. So usually, this will come up, obviously with seniors in high school sometimes, but usually this comes up with college kids, that mom and dad are footing the bill and they want to know how, you took it, this is my kid attending class, like I want to see the attendance records. And most, unfortunately, the first reaction at most colleges is, oh, we can't tell you that information, it's for the student. That's not true. If the parent still claims that student as a dependent for IRS purposes, they do have a right of access to that information. I plan on using that when my child is...
Documentation purposes or?
No, in that I would take their word for it. I don't want you guys to start collecting IRS tax information. I would just take their word for it. I just would. Sure.
My nephew that is attending the University of Texas at Austin has never shown his parents his report card.
If they claim him as a dependent for tax purposes, they have a right of access. They have a right of access to that information.
You are so concerned.
Oh, I'm just giving a big serious.
Without consent of the student. Without consent of the student.
Okay, and my sister, who has a 22-year-old that's going to the University of Texas Arlington, she's paying for it.
Same thing.
Okay.
As long as they're still claiming as a dependent, then they have a right of access under FERPA. But I guarantee they do. They don't. However,
With dual credit, we get that sticky wicket a lot.
right. However, if you throw out the word FERPA, if you say, I know under FERPA I have rights to access this information, they'll go, you'll hear just a silence at the other end of the phone. Like, oh, it's gotten out. So, yes, you can access.
It's blowing my mind. I cannot imagine growing up in my parents' home who were paying the ticket for me to go to college.
Oh, no way.
And even thinking that I could get by without showing the
Had to
report
show mine
card.
to get back in the house.
Right.
Good to know. Very interesting.
My daughter's only a year and a half, but I'll be using this. So, any questions about who has access to education records in terms of parents and eligible students? Okay. A district can disclose education records to any person, anybody, any organization, if you have parental consent or consent of the eligible student. Or if one of the very few limited exceptions to FERPA applies. Consent is sort of the golden rule. If you have parental consent to release information, you don't have to go any farther. You don't have to look at, is this directory information, do one of the exceptions apply, etc. If the parent has consented to disclose the information to whomever, done. The other,
Very often.
sorry?
Do they do that very often? Are they still giving? Because I do remember getting the consent forms that a lot of parents don't read, where they're signing away a lot of rights sometimes.
Well, the thing, and we'll talk about what I think needs to be in that consent form, and it's pretty specific. So it can't be just a blatant, I agree for blank ISD to disclose to any individual. It's got to be specific in terms of at least to an organization or to an entity, etc. And this consent can be revoked at any time. The other way to release education records is if one of the exceptions applies. Otherwise, disclosure of education records and personally identifiable information violates FERPA. So first, this is the biggie exception. This is the one that is going to likely apply 9.8 times out of 10. And this is school officials who have a legitimate educational interest can access education records and personally identifiable information of students. First of all, who is a school official? It's generally any employee, agent, contractor, or outside service provider that's used by the district to perform educational institutional services. So it doesn't necessarily have to be somebody who's a direct employee of the district. It can be somebody like you guys who's a contractor or otherwise an agent of the school district can constitute a school official. What is a legitimate educational interest? It's numerous things, including all the ones listed here. It's working with a student, considering disciplinary or academic actions, a student's particular case, like an ARD matter, or an IEP for a student with disabilities. So in your example earlier of you get phone calls of, we're about to go in an ARD meeting, and I need this information. If you verify that the person is who they say that they are, and that they are in fact going to an ARD meeting, that's a legitimate educational interest to have access to those education records. Also, compiling statistical data. So if you guys were doing an internal study to decide, which courses are being utilized more often than others, some sort of statistical data, that's an exception to FERPA. Also, reviewing an education record to fulfill the official's professional responsibility. This is sort of the broad catch-all. Do you need this information to do your job? If so, that's likely a legitimate educational interest. Now, earlier we were talking about, you'll get phone calls, help desk will get phone calls, and they'll want to start telling you the life history of this kid. Do you really need to know all of that information, or do you just need, it's a sort of a need to know basis. What information do you need to know in order to perform your job? That's a legitimate educational interest. And finally, investigating or evaluating programs can be considered a legitimate educational interest in a student's records. So, the general rules with regard to FERPA. Disclose to the parent or the student upon request. Remember, the parent or eligible student has a right to inspect and review all education records. No right to copies unless that's effectively preventing access. The right's incredibly broad. It encompasses virtually every document that relates to a student. The consent of the parent or 18-year-old student is required for disclosure to anybody else unless one of the exceptions applies, like a legitimate educational interest. So what should that consent look like? And I think I forwarded to you guys before, but I'm happy to send it again. It's a one-page FERPA consent form that meets all of these requirements that just has blanks where you fill in the blanks. So consent of the parent or 18-year-old student is required for disclosure to anybody unless one of the exceptions applies. What should the consent look like? Obviously, absolutely needs to be in writing. It needs to be signed and dated. It needs to specify the records that may be disclosed. Maybe it's as broad as all education records. Maybe not. Maybe it's records relating to this particular course. But it does need to specify which records can be disclosed. It needs to state the purpose of the disclosure. You can disclose this information to my school districts, to my student's particular campus, in order for them to adequately calculate his GPA, or to make sure it's an official part of his transcript, etc. Identify the party, or it may be more than one, a class of parties, to whom the disclosure may be made. Who is the parent giving consent to view these records? Is it the whole school, a particular school district? Is it a medical provider? Is it a particular campus, a particular teacher? Who is the consent? Who does the consent relate to? Importantly, contrary to the general rule that parents and eligible students are not entitled to copies of access, but are just entitled to access of information under FERPA, If they're giving consent to release it to a third party, they do have a right of copies for that information that's being released to a third party. The required signed and dated written consent, the FERPA police has finally told us, can include a record and signature in electronic form. The electronic consent, though, has to be signed. It has to be, like, for example, an electronic actual signature, not just a typed Sarah Langlois, parent of Ella Langlois. It's got to be an actual signature. So keep that in mind for consent. And again, I've sent you guys a few years ago, it hasn't changed, that FERPA consent form. But if you need it again, I'm happy to send it. Okay. More exceptions to FERPA. When is parental consent not required? The biggie was legitimate educational interest. If a school official has a legitimate educational interest to access that information, you don't have to get parental consent, you're fine. Other exceptions to FERPA include a request by school officials at a school in which a student is seeking to enroll or is receiving services, provided that the sending school complies with FERPA's notice and hearing requirements. You just have to provide notice to the parent or the eligible student that you're sending those records to that particular school. A request by various state or federal officials for audit, evaluations, and enforcement proceedings is an exception to FERPA. A request to determine eligibility for and the terms and conditions of financial aid is considered an exception to FERPA. A request by an organization conducting a study on behalf of the educational institution. And finally, a request from accrediting organizations are all exceptions to FERPA. The exception to FERPA that I most often deal with are judicial orders or subpoenas. If you receive a subpoena for an education record, notify your supervisor immediately, who should then in turn notify Ms. Truitt, who's the Executive Director of Human Resources here at HCDE. And then she picks up the phone and she calls me because the rules are pretty complex. It's an exception to FERPA to comply with a lawfully issued subpoena. What's a lawfully issued subpoena? Beyond our scope today. That's why they hire me. Job security for me. And so they'll send me a copy of the subpoena and I'll make sure that it's lawfully issued. And then usually what I'll do is ask for the copy of the records responsive to the subpoena, and I'll go through them and make sure they're responsive to the subpoena. And importantly, what often comes up is that educational records can sometimes either be the education record of more than one student or contain personally identifiable information of more than one student. And so if the subpoena is only asking for records for a particular student, I'll redact all of the other information because it's not responsive. So the request...
Our twist on that one, Sarah, is that technically our contract, Region 10's contract, on which HCD is a sub-partner, is they say the data is theirs, the TEA owns the data. So, but in our recent conversation with the agency, when PIRs and that kind of thing went through, they said, oh no, we want y'all to handle that through your system. They said, it's your data, but we're supposed to handle it through our system. So,
interesting.
We're straddling and picket fence on that one in particular.
You absolutely are, because, I mean, whether it's for a subpoena or for the TPIA only applies to records that are maintained by that governmental entity. So if TA is saying, oh, it's ours, well then you need it, right. But in the absence, we want to be friendly with TA, then, I would continue to comply with it. If we maintain the information, if we have it.
Well, in cases in general, I don't think we have much that anybody would want. Although somebody's just blanketing, subpoena didn't pull in everything they get, I guess they might get us.
Yeah, and even on like a big TPIA request, Tammy Lanier will call me and I'll review the documents and make sure, do we really maintain this? Is a third party affected? Because there's rules about if it's a third party's information. Y'all don't need a lesson on TPIA today. Be thankful that you don't get many TPIA requests, I will say that. So the thing to take home today is if you do receive a subpoena, in the unlikely event you are subpoenaed for information, make sure you get it to your supervisor immediately, who will forward it to Ms. Truitt, who will forward it to me. Most subpoenas will say something along the lines of, these records are to be produced on instanter, which just is a fancy word for immediately. And a lot of times that scares people of, oh my gosh, I'm going to be found to have violated, not complied with a subpoena if I don't hand over these records immediately. No. FERPA requires that we provide notice to the parents and an opportunity basically for the parents to object to our releasing the records when we're complying with a subpoena.
Is there a time frame to that?
It's a quote-unquote reasonable time.
Thank you.
Do you think they've ever dealt with the TEA? Because reasonable to them is very different.
Yeah, and so of course the FERPA police have not, we've asked, school attorneys have asked numerous times, what does that really mean? I mean, if, because a lot of times we'll get subpoenas for records, and for one reason or the other, whoever is issuing, whichever party or individual is issuing the subpoena has waited till the last minute. It's the DA's office or an attorney or whatever, and they need the records, in 3 days for this court proceeding. Well, in that case, we do our best effort to get the notice letter out to the parents and wait till the last possible minute to provide the documents. But there's of course no definition for what's considered to be a reasonable time to provide the notice to parents.
And we wouldn't have parent records to even know who to contact. The school district would.
Which is likely why you guys wouldn't be subpoenaed. It'd be the school district that would be subpoenaed. Right, exactly, and then they can turn around and request the information, whether it's to comply with a subpoena or if they have a legitimate educational interest or whatever the case may be. Hopefully you guys won't deal with this, but just FYI, no parental consent is required if it's a request by officials in a health or safety emergency. So, for example, if knowledge of the information is necessary to protect the health or safety either of the particular student or of other individuals, you can disclose the information. It's got to have an articulable and significant threat. It has to be a true emergency for the health and safety emergency exception to apply. When I do FERPA trainings for school counselors, we spend like 45 minutes talking about what the health and safety emergency exception is. Because, for example, the student comes in, tells you they're pregnant. Can you tell mom and dad? Student comes in, tells you he's HIV positive. Can you alert the coach of the football team on which the student plays? All these sort of messy. So be grateful that, although FERPA applies to you, you very likely are not dealing with the health and safety emergency.
So I'd like to know the answers to those questions.
I was going to say, I'll invite you to my next FERPA training.
My child, and they said she might be somewhere taking an online course. Can you tell me if she's enrolled in an online course?
Exactly.
We got that one last summer.
Yes.
That's an interesting one.
Yes, we did.
I'm going, okay, I don't know how that's going to help you, but.
Well,
And
or
we
they,
end up sending
but it
you
was,
back to the contact
but is
person
it the
for
parent? It was the parent.
Allegedly.
Yeah, it was, but you're on the phone.
Right. In that case, I would hang up, take the person's information down, contact the home school district, verify that the person is who they're saying they are. But remember, this only comes into play if it's a third party who's accessing the information. If the parent is asking for the information, they have an inherent right of access. But if it's, and that, remember, goes into that definition of parent that includes somebody who's taking care of the child in the absence of the parent.
But how do you know? It could be crazy Uncle John calling.
It could be crazy Uncle John calling. And so that's where,
To the district and thought,
Yeah.
we'll work with the, need to work with the district.
Right.
And let the district.
because at the end of the day,
us-
the district is the one who's going to be more likely to have the specifics about that particular child. I mean, is Uncle John really crazy Uncle John, or is he the one who is the president of the PTO and picks the kid up from school every day and is at every snack time and lunch event and etc. But so that's excellent. I think that's a good practice, is to, when you can, refer the individual back to the home district, or at least work with the home district to verify that the person is who they're saying that they are, and getting them the information that they need. And the answer to all those questions is maybe. Or it depends. Take your pick.
Another favorite.
Another exception to FERPA is for organizations that, I think I skipped one. Did I skip one? Let's see. Oh, no, health or safety. Organizations conducting studies for or on behalf of educational institutions. No parental consent is required. It applies when a school district discloses personally identifiable information to a third party. However, you have to make sure that the third party has an absolute right not to violate FERPA. If they do, so if the third party takes the FERPA protected information, they're conducting a study on behalf of the district, and then they redisclose it to another person, the 5-year rule kicks in, which says that we can no longer disclose FERPA protected information to that third party for 5 years. So it's a pretty hefty penalty. If you're internally conducting a study, that's one thing. If you're having an organization outside conduct a study, call me, because the definition of study is pretty limited. And so it's not just, oh, we're conducting a study. It has to meet the very specific exceptions of the study exception. Also, hopefully you guys won't be having to deal with this either, but I throw it out there just so you're aware of it. The Texas legislative session before last attempted to meet the FERPA exception for juvenile justice service providers. And I say attempted because, in my opinion, and in the opinion of a lot of school attorneys across the state, the legislature went a little too far in how they attempted to grant access to FERPA protected information to juvenile justice service providers than FERPA actually allows. So currently, Texas law requires the disclosure of a student's confidential information to a juvenile service provider upon request in two very finite situations. First of all, what's a juvenile service provider? Juvenile justice or prevention services, if they're providing medical services, education services, other support services. The definition is very broad. DPS, TEA, an individual ISD, a JJAEP, a state or local juvenile justice agency, health and human services. The list sort of goes on and on and on. A local mental health and mental retardation facility. All of those could be juvenile justice service providers. However, if you get a call from one of these individuals, and the DA's office is one of the ones that really attempted when this law was passed to come in and say, great, we don't have to issue subpoenas anymore. We have this juvenile justice exception. We can just access the information without having to issue a subpoena, and we don't have to wait that reasonable time in order for you to notify the parents, etc. Maybe. The juvenile justice service exception only applies in a very specific circumstance. If the student's actually been taken into custody or referred to a juvenile court for allegedly engaging in delinquent conduct or conduct indicating a need for supervision, and the purpose of the disclosure. So you have to ask, why do you want this information? If a juvenile justice service provider is calling and asking for information and saying, oh, but there's that new law, you can just hand it over to us, not so fast. Why do you want it? The purpose of the disclosure has to be to identify a multi-system youth, so to identify if the youth is being served by multiple agencies, to coordinate and monitor care for a multi-system youth, or to improve the quality of juvenile services provided to a multi-system youth. It's a pretty narrow exception, and it has to be to serve the youth. Is the DA's office serving the youth by attempting to adjudicate the student? Maybe. Because this exception is new, In judgment call type situations, my advice is I'm going to demand a subpoena. Because it's easy for somebody like the DA's office or any of these juvenile justice service providers, because they're governmental entities, to have a subpoena issued. And that way, it's just clearer. You're not making all these judgment calls about, are you serving the youth? Has the youth been adjudicated? Where is he? What's the purpose of the disclosure? All that kind of stuff. So if you get a request by a juvenile justice service provider for information, if they don't have a legitimate educational interest, they're telling you, oh, I'm entitled to this information because of that new law, that should raise a red flag. That's one of those times where you should take their information down and tell them you'll get back to them. Because when in doubt, remember, demand a subpoena. Okay. Some takeaway tips. Anytime you receive a request to access or review student education records, you should make sure, ideally, when you can, that the request is in writing, it's signed by the person requesting the information, and dated by the person receiving the request. Now, I understand because of what you guys do, that's just impractical for you. This is not legally required. This is if we are in an ideal world. This is what I'd like to see. However, we're not in an ideal world, and the practical circumstances dictate that you have to give people information over the phone. In those instances, what I most importantly want you to take home today are two things. One, that now that you know what FERPA is and to what information it applies to, and number two is to take reasonable precautions to verify that the individual is who they're saying that they are, and that they have a right of access to that information. So there are numerous ways to do that. If it's somebody who can send you a court order, or if you verify with the district that the individual, Pat Smith is the parent of John Smith, things like that, that's okay. Also, be aware that records may contain personally identifiable information of more than one student. And so you should redact the information relating to the quote-unquote other student. So if mom calls and she wants a roster of all students enrolled in her son's particular class, are names protected under FERPA? Yes. So in that case, what can you do? You issue the roster to her, only with her kid's name shown. You redact everybody else's. So that's just be aware that a record can contain personally identifiable information of more than one student. More things to remember. Emails. Every time I do this, sorry. Beware of email. Every time I do this presentation, I think of Jim Schul, who is the HCD's Chief Information Officer, because he tells us all the time, Sarah, he says, technology is our friend, and it is not the tool that is the problem. And yes, Mr. Schul, that's correct. However, I'm not changing my slide of beware of emails. Remember, when you are emailing somebody about a student, you just created a record. Whether you intended to or not, you just created a record that likely could be an education record under FERPA, and most definitely is likely public information under the TPIA. So whether you intended to or not. And so remember that you can only share personally identifiable information and education records protected by FERPA to parents, eligible students, or if one of those exceptions applies, i.e. The most important one, school officials with a legitimate educational interest. So be conscious of using emails. For example, subject lines, a lot of times I caution individuals to not put a student's name or social security number or some other identifier in the subject line, because that can be viewed by numerous different people. It's easily viewable. Also, just be on the lookout. Same thing, the same rule applies to emails that it does with over the phone. Take some precaution to verify that the individual who is emailing you is actually who they are saying that they are, just like with over the phone. If the parent or eligible student requesting the record provides an email address, there's no FERPA violation for sending the information to that email address. But I would take precaution to verify the email address, i.e. calling up the home district and asking, which email address do you have on file for this parent? It matches, good to go, you can send them records. As I mentioned earlier, there's good news and bad news with regards to liability under FERPA. The good news is there's no private right of action under FERPA. What does that mean? That means that if you sat in this class today and you thought, oh gosh, I sent so-and-so this information about this kid, I probably wasn't supposed to do that, am I going to get sued? No private cause of action means mom or student cannot sue you under FERPA for disclosing information that you should not have disclosed. But plaintiffs' attorneys have gotten creative and they've found other causes of action that they've attempted to use, like invasion of privacy, things like that, in order to bring civil suits. Very rare, so I'm not trying to instill fear in you, but just be aware. The bad news is that under FERPA, the violation for violating FERPA is a loss of federal funds. However, the FERPA police are typically generous in terms of, they definitely give warnings, slaps on the hand, that sort of thing for violations, for initial violations of FERPA, and only revoke federal funding if it's a consistent pattern, just blatant refusal to comply with FERPA. Also, bad news is violation of FERPA is good cause for termination of employment, so comply with FERPA. Okay. Other laws of which to be aware, we've talked a little bit about the Texas Public Information Act. An HCDE open records request need to be submitted to Tammy Lanier. When I say must be submitted to Tammy Lanier, I mean if you receive an open records request, you need to immediately forward it to Tammy Lanier. You cannot require the requester to email Ms. Lanier directly or to submit it through the open records office. Under the TPIA, an individual a requester can submit a request for information to anybody. You don't have to require them to go through the particular office. Also, remember, FERPA is federal law. State law, specifically in the Education Code, section 26.004, provides that a parent is entitled to access all written records concerning the parent's child, including the things listed here: test scores, attendance records, counseling records, things like that. So in addition to FERPA, Texas law also allows parents a right of access to information. Okay. We're going to end with a test. So, to whom can you give records? You receive a call or you get an email or contacted some other way by a teacher for a particular student's education records. Can you give it to them?
Maybe.
Maybe. Very good. If what?
Do they have a legitimate education interest in that?
Ding, 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 ding. You all were paying attention. You can give education records and personally identifiable information to teachers or other school officials who have a legitimate educational interest. What about to the school nurse or to a nurse at a doctor's office that tells you that they are taking care of this particular student?
That's what we have in education need.
If they have a legitimate educational interest or in an emergency, a health or safety emergency, or if you have consent. Because remember, if you have consent, that's all you need. No further questions asked. What about police officers, SRO officers that are assigned to a campus?
If they have a subpoena ordinance.
They're either way. They're either contractors or employees of the district. Either way. Only if they have a legitimate educational interest. What about HPD? HPD comes in, or the DA, somebody from the DA's office comes in and says, we have taken this child into custody. We need the records relating to this child. Yes, that's when you say, hold on. No, HCD, the general answer is no, that they're not, HCD is not an arm of the law. HPD or the DA's office or anybody can't come in and demand right then and there that you have, that they have access to education records. What about to the home district? Somebody calls up from the home district and wants information about particular kids. Verify who they are. But do you just turn it over to them? If they have a legitimate educational interest. What about to parents? Parent calls. If they're under 18 or
they're dependent.
I have a feeling that the most important thing everybody learned today is that when their kids get into college, they can ask for their their records. What about to students? Student comes up or calls or emails and says, I want my grades from this particular course, or I want whatever. If they're over 18.
18 years old.
If they're over 18. Otherwise, who the FERPA rights belong to? The parent. That's right. Very good. Thank you guys so much. Any questions? We covered a lot in a short amount of time. But if you guys have any questions, I'm happy to answer them.
We have on all these different providers who send us invoices, and what we tell them to do is put this order number on there, because that ties back in our database to all who the student is and all this kind of stuff. They inevitably send us invoices that have students' names on them.
In that event, you are not violating FERPA. They may be. Hopefully it's none of the districts I represent. But
Not naming names.
thank you. But in that case, what's important is for you not to redisclose it to to somebody else.
We literally do redact it when we
That's
send it to our business office. for
perfect.
processing.
Perfect, because I wouldn't want us to get in trouble in terms of that 5-year rule of we're getting access to legitimately getting access to FERPA protected information, but then redisclosing it to the business office who has no need to know
Oh, absolutely.
which kids attended which class.
And if they would use the bloody order number, we didn't make it happen. Thanks, Susan. Then, one of the requests we get, because we pay the provider that we collect from the student's district for the course cost. One of the things they ask us to do is, at least on the invoice we send, is we send the course order number, we send the course name, we send the campus it came from, all this kind of stuff. They want us to put the student's initials on there at the very least so that they can tie it to a specific student.
When you say they, the home district does?
Yeah, we get that call all the time. Is there any way you could put this on here? Because it would help us figure out who the kid is.
I think that's a legitimate educational interest. Because it's, in order to do the job of getting the bill paid, they need to relate it to a particular child. So I think that that's okay.
It's a lot of personally identifiable information,
But remember, if it's a legitimate educational interest, and that thankfully is very broad, that definition, then it's okay. Then it's fine. Any other questions? Awesome. Thank you guys very much for having me today. I appreciate it.